Why get out of it? Nobody's gonna make it in New York. Everything's shut.
We are live in public session.
Yeah, I can. I like my own exercise.
That's sad. Good morning, how are you? Good, good.
I have not figured it out.
We're live. We're live in Albany here.
Yes.
Okay, we're ready to come to order here. First item is approval of the minutes. Can I have a motion?
Commissioner, Mr. Chairman, yesterday I'd had a conversation with Commissioner Weissman, who pointed out actually strange typo on page 5, line 4 at the end. The word "dad" should probably come out, since that's not a word. It should be read, "This has been a long-term philosophical issue." So that's a typographical error that we'll just note in the,
Well,
would be noted.
Good that was noted. On the dad term, philosophical issue, all right. I must have skimmed right over that. Okay, with that change, with that one change, do we have a motion to approve?
So moved. Second.
Thank you. Second? Yes, thank you.
Like, Commissioner Knox?
Yeah, it's hard to
Commissioner
see
Knox,
faces,
seconded.
but yes. All in favor? Raise your hands, please.
All in New York.
Any opposed? Okay, thank you. Report from staff. Seth, you want to take this?
Sure. Just first off, and we'll go into some other, obviously, personnel matters later on, but as you know, our long-term institution, Deb Novak, retired. We have Catherine Santandrea, who is sitting at the end of the table, who has taken over those duties, and this is her first meeting. So just wanted to explain all that. I still have not heard from Deb today, but I think she will find it hard breaking the habit, so I imagine I will be in touch with her regularly for a long period of time. Outreach activities.
May I ask a question?
Absolutely.
We adopted a resolution, did we not? About her, the last meeting.
I don't believe so. I don't think
It
that,
wasn't a formal resolution, it was recorded in the...
it was recorded in the minutes.
All right, thank you.
Outreach activities. I'll talk about CLE first. There's going to be our CLE, actually, if you're interested, the State Bar is going to be having a CLE on 10/12. I'm going to be on a panel talking about lobbying. I understand Commissioner Yates will be doing an hour discussion about the executive budgeting process. That's going to be up in Albany. Our CLE that JCOPE is sponsoring is scheduled for October 26th down in New York City for 3 ethics credits. That is all set to go. We have a book that is going to be made part of that proceeding that we'll distribute. Actually, will be free to everybody. A real survey of the ethics laws, lobbying laws in New York, even a chapter on history of ethics laws and how they've developed in New York. And that will be at 2 o'clock, I believe, on the 26th. But that is scheduled to go at the New York Law School.
2 till 1?
2 to what? Is it 2 to 5, Monica? It's got to be 5, yeah.
Yes, 2 to 5.
Update, ethics reminders. We sent out our ethics reminder on political activities. It usually goes out this time of year to remind folks what they can and can't do on time and on work time for the state workforce. We have an outreach on the hotline, the ethics hotline. That has gone out to the general counsels and all of the ethics officers. We have a forum, September 26th, with ethics officers, going to be held here as well. And so our outreach activities, our education component here is very, very busy. It's really there's something going on almost every week in terms of dealing with educational initiatives. That's certainly something that we do. One of the many things we do very well here and with Keith and Megan. Good job. Pardon me?
We've got a robust program.
A very robust program, and we're trying to, part of what we're trying to do, and the commission has been very clear about it, is looking at agencies and specific problems so that the agencies become the first line of dealing with a lot of these issues, helping to recognize the issues that are unique to various state agencies, so perhaps they don't come to us, that they can take care of these issues before they develop. So that's been the focus that we've had. But that's where we are in our outreach activities.
Thank you. Item 4 on the agenda, regulations. Monica?
So I'm just to update the commission on where we are with the rules that the commission voted to proceed with the last meeting. With respect to the comprehensive lobbying regulations and the corresponding changes to source of funding, those are out for public comment. The deadline for comment is October 16th. We're also planning to hold a public hearing in Albany on Monday, October 30th at 1 p.m. in the Legislative Office Building in Hearing Room A. We anticipate that we will be, after the chance to review and absorb all those comments, that we would be bringing the regulations back to the commission at the November meeting for discussion. In addition, the records access regulations, which were amended, were voted to amend and move forward with rulemaking at the last meeting, those are out for public comment. The deadline for comment on those regulations is October 9th, and we anticipate bringing those regulations back to the commission at the October meeting.
One last thing, just on the slobbing and source of funding, just to highlight what Monica said, the deadline for public comment is October 16th. That'll be 2 weeks before the hearing. So we'll be able to get those comments out to the commissioners certainly well before the meeting, so that we can have a hot bench when we do have testimony. So,
Monica, do you want to say anything about hearing officers?
I was going to discuss that, but in an executive session, but I guess for the public, that's okay. For the public, we're working on expanding our pool of hearing officers, and there's a hearing officers subcommittee that has met, and we're doing outreach to increase our existing pool of independent hearing officers.
Thank you. Item 5, this is NICLU.
Well, no, we're still in, sorry, Chair, we're still in regulations. We have some proposed amended regulations before the commission, so Martin was going to present on those.
and that's exhibit.
Sorry,
That's
Martin,
exhibit.
are you off?
And that's exhibit B, by the
Yes,
way.
these are.
Always glad to talk about regulations. So these are on the agenda. If the commission, I'll go over them, and if the commission elects to proceed, it can vote today to commence a rulemaking, and if not, we can talk about it next month. This derives out of a commission request to staff last month that all financial disclosure statement related regulations have a right of appeal from to the full commission from any determination by the executive director. So this comes up in cases where a filer might request that certain information be redacted from public view, or the recent applications for, the recent regulations that the commission promulgated relating to disclosing client information on your FDS. And also for filers who are requesting an exemption from filing, should they not be policymakers. So this is carried out in, to be clear, these are non-emergency regulations, so we are not requesting any immediate effectiveness or effective date, hoping immediately effective. Starting in Part 935 of the Title 19, which relates to an exemption from filing an FDS, Part 942, which is an exemption from disclosing client information, Part 941, which is your adjudicatory proceedings and appeals, and this is the mechanics for the appeal. And then Part 936 is the extension of time to file an FDS. We're not adding a right of appeal here, but just updating the name in the regulations from our predecessor, the Commission on Public Integrity, up to JCOPE. So it's purely clerical in 936. Everything else was done to effectuate that requested right of appeal, and there are no other changes proposed.
Commissioner Weissman is requesting to speak, Mr. Chair. I don't know if you see that, but.
Has any, in 935, specifically 935.3, has any consideration been given to providing some information to the commissioner, to the commission itself, relating to, say, the number of exemptions that have been granted by the executive director? I mean, I'm not, this could be done in two different ways. Either publicly, publicly it would be just a gross number, and if the executive director thought there was a particular set of class or particular exemption requests that should come to the commission, he should notify the commission on, that would be more appropriate in the executive session.
That kind of triggers a number of different processes that already exist. We didn't put it in here because these regulations deal with each individual application. And so they're designed to treat an individual application through the process.
Is there any place that,
I mean, it certainly can be effectuated. I don't know that it needs to be codified, but if it's something that you want to include, we can bring it back with updates to reflect.
Yeah, I mean, I just think it's, I think it's good public policy and provide some transparency.
We could certainly have maybe a general requirement, either through our own policies or in the regs, that the executive director report regularly to the commission upon such exemptions as may be granted.
Yeah, I mean.
And just leave it open at that, so that there's some.
Because generally, I mean, they come in two different groups. I mean, they come with May 15th, and then the academic filers come in, what, July 1?
November 15th.
November 15th, so, I think that would be, it's somewhere based on those timeframes, be sometime after that we would, you could just report. And it seemed to me in reading this, that might be a good place, this might be a good place to put it.
Yeah, we can add that.
It's a good idea. We'll make it express in the regulations.
Yeah.
At a minimum
Yeah.
after each filing period, or monthly if you'd like, or.
Well, I just, that piece I leave to staff.
The executive, and we'll put that in, that's
Yeah,
a good
okay.
idea.
So, Commissioner Weissman, you actually want it in the regulations?
I think it would be best. I mean, I would defer to the other commissioners as to whether or not they believe it's appropriate in the regulations.
What I was just going to suggest is if the commission is comfortable with it, I think if the commission is otherwise prepared to move forward with the rulemaking, which allows for public comment, that the commission could vote with the understanding that that language would be added to 935 and 942.
Yeah, and 942 would be the other place that I had made this comment. So thank you very much, Monica, for picking that up.
Right, so what I'm suggesting is the commission could still vote to move forward with the understanding that we're going to add language to that effect to those two sections, along the lines of what the executive director recited.
Yeah.
Yeah, we'll make it very clear, and it'll be expressed in there.
I'm fine with that, Monica.
Do we need a vote?
If you'd like to proceed, then yes.
Yes.
Yeah, we do.
On the general.
With that proviso that Monica just went through, I think we need a motion to proceed to rulemaking now so that we can go to public comment.
So moved.
Do I have a- Thank you. And a second?
Second.
Thank you. Okay, all in favor?
New York unanimous.
Albany as well.
As is Albany.
Yes, if you can't see, Commissioner Smalls is here.
Oh, wonderful. Yeah, as is Albany.
Any opposed? Okay, thank you. Now we go to item 5. I'm going to wait for a moment. I'm going to step out.
At least one person knows what they should.
This is NICLU's application for exemption from source of funding disclosure requirements, attachment C. Go ahead, Monica.
So what's attached behind tab C is an application from the New York Civil Liberties Union for a what we call blanket exemption for all its sources of funding pursuant to 19 NYCRR 938.4B. So they're applying for an exemption so that they would not have to disclose all of their sources of funding. This is available to 501c4 organizations which show that its primary activities involve areas of public concern that create a substantial likelihood that disclosure of its sources will cause harm, threats, harassment, or reprisals to the sources or of individuals or property affiliated with the sources. And the Commission has regulations which set forth 5 factors the Commission should consider in making this determination. There's a non-exclusive list of factors. The factors include specific evidence of past, present harm, threats, harassment, or reprisal to the sources or the client filer or individuals or property affiliated with the sources or client filer. There are, like I said, there are 5 factors, and these are laid out in the regs, but, and we can discuss them if anyone has any questions. I don't know if I have to read all 5. As the commissioners are considering what action they're going to take, if a commission is voting, need to have a clear record of the reasons for the vote. If the commission does not vote to approve the application, any letter of denial must include a statement of findings and conclusions and the reasons or basis for the denial. It's very important that commissioners state the reasons for their vote so that we have a clear record. If there are any questions about the legal analysis, I'm happy to answer them. Otherwise, I'm going to turn it over to Andrew Broussard, our Director of Lobbying, to just discuss the application, the most current application itself.
Thank you, Monica. So once again, this agenda matters to have the Commission make a decision and make a record on this request for a blanket exemption from source of funding disclosure requirements. NICLU, in its exemption application, provides evidence of several new documents received since December 2016, containing what they describe as threats and harassment. The evidence appears to include 10 holiday cards, 3 letters, 14 assorted photos or posters, which includes statements like, quote, "I sure hope no terrorists bomb your building," unquote. Quote, "To the ACL Jew, may your loved ones be the next victims and not mine," unquote. Quote, "Every one of you, your mother, expletive, should have been aborted," unquote. Quote, "God is waiting to send you to hell," unquote. And some of these were added to statements that are in holiday cards. So, quote, "Peace on earth without you," triple underlined of the "without you," unquote. Quote, "Take your group out of the USA," unquote. Quote, "Terrorists will nuke New York City," unquote. And there's accompanying that statement a picture of a prophetic warning. The NYCLU argues its members and supporters have historically been subject to periodic and unremitting harm, threats, and harassment, and in past requests have provided documentation regarding bomb threats to New York City and upstate offices, vandalism on the vehicles of members, and that they've had to take protective anonymity measures that must be taken by staff who answer the NYCLU phones to avoid being publicly identified due to threats. NICLU also argues in its application that past denials of the Commission have incorrectly applied the Commission's own regulatory scheme and disregard the statutory mandate to protect donors of not-profits that do controversial work in the public interest. Included as appendices to the request, which we received on July 13th, 2017, are the May 2017 Commission denial letter, the January 2017 request for exemption, including attachments, the July 2015 request for exemption, including exhibits and attachments, and those exhibits and attachments include the July 11, 2014 Pratt decision, the April 24th, 2014 NICLU appeal letter, and the December 3rd, 2013 exemption request. Of course.
Chair?
Commissioner Jacob.
There have been how many?
I didn't hear.
It's Commissioner
Yeah.
Jay.
Oh, go ahead.
How many?
Yeah, go ahead.
How many denials have there been of NICLU's applications? They've been denied, I think, at least twice. Is that true?
At least twice.
I think
Yes,
3
Mark?
times, but
3 times? That could be.
Hang on one second.
I think at least 3 times.
When was the first denial, if I may?
Looking through the history now.
In 2014,
So what have they been doing since 2014 to date with regard to disclosing their donors?
correct me if I'm wrong, Martin, but I believe what they've disclosed are a very few, but a handful of donors, mostly institutional in nature.
I've just handed the commissioner the disclosure forms, which were copied off of our website.
So they've disclosed the 1, 2, 3, 4 donors. Is that the sum total? I'm trying to figure this out.
Yes. There are 2 different filings there. One has 1 donor, and the other has 3 donors, I believe.
And in the period prior to this first filing you show me, were there any disclosures made with this agency or its predecessor? Or was there no requirement to disclose?
I think of the predecessor agency, there was no requirement, and
So there was no disclosure?
that's correct.
And since they did not get any exemptions, they've only disclosed this small number.
Yes.
Have they made any statement with regard to the loss of revenue as a result of these denials?
I don't think that they discussed that in their applications.
Their application includes their prior applications, correct?
They do.
Okay, so for purposes of this discussion, I'm going to incorporate by reference my prior statements, I think from April, which incorporated by reference statements that go further back relating to their discussions before we start this. Okay, and I have other things to say, but I'll let other commissioners go.
Andrew, if I can just ask one quick question so the record will be clear. Are the individuals that have been listed now as sources, are they the subject of any of the attacks or other incidents in the application?
Threats, harm, reprisal?
Right,
Yeah.
they listed in the application, so these donors who've already disclosed have not been the subject?
No.
Okay.
And is the reason there was 1 and then 4 is because of the lowering of the statutory threshold for reporting? Was that a?
I don't think so.
No?
No.
Where is their filing for 2016? You've given me 2014 and 15.
Yes, I wasn't able to locate that particular filing.
Well, have they filed in 2016?
To look it up. I can.
We're checking on that.
I'm being informed that, yes, they have filed for 2016.
Filed for the first half and asked for an exemption for the second half.
So do we have that filing available?
I think Martin's pulling it up.
Yep.
We're just doing long distance search on the computer with our So in the meantime, we are looking, we're going to pull up that filing. Usually sources of funding, when they are disclosed specifically on the webs. We actually have a link that says sources of funding. So when those are there, those are available to the public on the website, and there are dozens of those instances where there have been disclosures.
Obviously, you guys know how to use our computer stuff, our website, right, better than some of us.
There is a reason we're rebuilding it.
That's true, too. We are going through a major redesign on lobbying to get us somewhere into the 21st century in terms of making it more user-friendly to the public and to us. We have a lot of information available, but
It's not going to work on the iPad.
okay.
I'll run upstairs and get it.
We'll go upstairs and physically get the file. This is our computer. Do you want Lori to get whatever you need?
Yeah.
Lori will get that. So you can continue with the discussion, please.
First and second half is 50.
It's not going to work on here. I have somebody bringing it down.
Hmm?
I have somebody bringing it down.
All right, someone's bringing it down. We're going to physically bring down the file for you.
That's, Seth, for the benefit of those of
Yep.
us in New York, just tell me what it is you all are reviewing.
This is the document that the director of lobbying produced, just showing for 2015 the disclosure of sources from NICLU. We've sent someone upstairs. We'll be bringing down the actual physical filing for the most recent period,
2016.
which we don't have in front of us now, and
Bring it down.
it's on its way.
Okay.
So that's what we're waiting for. It will be down here shortly. I imagine if commissioners wanted to continue discussing, we'll get that information if there are other items.
Well, while we're waiting, I ask a question. Madam General Counsel, do I understand correctly that the Civil Liberties Union is propounding that we adopt a standard of reasonable probability?
Yes, they've been arguing that in each of their applications, that the proper constitutional standard is reasonable probability. Our regulations and the statute use substantial likelihood of harm, which, often can be interpreted to mean reasonable probability. So,
Well, you anticipated my
has
follow-up.
not defined it.
You anticipated my follow-up question. Is the distinction they posit one in which you are accord?
I'm saying, are you asking
Yes.
whether or not I agree
Do
with
you
them that this?
There's a difference between reasonable probability and substantial likelihood.
I think that substantial likelihood could be interpreted to mean a range of things, which could include reasonable probability, and I would recommend that that would be the way that it be interpreted and be applied to be consistent with the constitutional case law.
Thank you.
Chair, next question
Yes.
for the general counsel. Isn't
Please,
the complaint, NICLU's complaint with the statutory standard, one which should be addressed by the legislature?
I know. I certainly think the legislature could address it, but I do think that the statute is clear that it gave this authority to the commission to develop regulations, and in developing those regulations, the commission can define and interpret standards, and it's for the commission to interpret the statute and interpret those regulations. And as I indicated, in case law that we look at, substantial likelihood can mean a range of things. So if the commission interprets substantial likelihood and applies it consistent with reasonable likelihood, which it's well within its discretion to do, then it should satisfy any constitutional.
Yes, but a range of things the legislature had the opportunity to consider, and at the end of the day, the legislature and the governor decided to use substantial likelihood. So,
At the end of the day, the legislature also decided to say that civil rights organizations, there's a presumption that they won't qualify for the standards. So if you're going to look at what the legislative history is, you got to look at the whole picture.
Yeah.
You can't pick and choose.
oh no, I'm picking and choosing the statute. That's all.
Yeah, and the legislative history is a part of the body of work that an agency is well within its prerogative to look at when interpreting the statute.
Yes, and the easiest way and the most direct way for an agency to carry out its mission in implementing regulations pursuant to a statute is to use the statutory language. That's the most direct.
And to follow constitutional mandate.
It's not for us.
That's
If I can suggest just a way of proceeding with this, is I think we have the statutory mandate. I think the commission, as it has done, will look at that statutory mandate and see if the evidence presents it. And like a court might also say, even had there been this other standard, make some, if it so finds, even if under a lesser standard, or another standard,
Difference.
or articulation of the same standard, this is how it would fare, so that whatever record we have will accord at least that fairness and set us on the record.
well, I'm sorry.
Sorry, can I just interject? So, Monica, if I understand correctly, the statute uses the specific wording of substantial likelihood and then gives the province to the commission to interpret it?
The statute uses the term substantial likelihood. The statute asks the commission, the statute gives expressly the authority to develop regulations to apply the source of funding exception application.
Got it. And so when, in your response to Commissioner Weissman, you said there are several ways of interpreting substantial likelihood.
Yes.
What are those, what are those several ways? I think part of what might help facilitate this discussion is if we know what the options are. You said that from a constitutional standpoint, reasonable probability is consistent with substantial likelihood, but if it meets constitutional standards, I don't know why we're talking about anything else. So at least from my perspective, you've alluded to other standards for substantial likelihood. And so it would help at least me to understand what the other options are as we as a commission interpret and implement regulations to effectuate the statute.
So to answer your question, there are no direct parallels to our situation that apply substantial likelihood. The standard in the similar types of disclosure regimes is reasonable probability. However, substantial likelihood appears in lots of other contexts, and it has been interpreted to range from reasonable probability to almost near certainty. And it varies. And so some of the examples are, quoting from a Seventh Circuit, it's like a substantial risk of serious harm, which is slightly different, but means that the risk was so great that it was almost certain to materialize if nothing was done. And that's in the context of an Eighth Amendment claim. In the context of sentencing enhancements for offenses creating a substantial likelihood of death or serious bodily injury, it does neither the guidelines nor case law define substantial likelihood. We adopt the meaning given to this language in the preliminary injunction context, namely that substantial likelihood means considerably more likely. And that's a Second Circuit opinion. And then in the context of ineffective assistance of counsel, interpreting substantial likelihood, there's a reasonable probability, M dash, that a substantial likelihood, M dash, that for his lawyer's failure to investigate specific evidence, the convicted individual would have been acquitted. That's Fourth Circuit.
So there's, and then what's the base of law that you draw on for reasonable possibility?
That's the First Amendment case law in the context of a disclosure scheme, which is out of Buckley v. Vallejo, Supreme Court decision. And that's where it had to do with disclosures of party contributors. And the court held that the evidence offered need only, that for the mechanism of disclosure was permissible, but there has to be a mechanism for some kind of an exemption, and the evidence offered needs show only a reasonable probability that the compelled disclosure of a party's contributor's names will subject them to threats, harassments, or reprisal.
So of the various options that you've provided us, it's the Supreme Court in Buckley v. Vallejo that specifically deals with disclosure.
Yeah, it's a different disclosure context, but it's
right. But that's the closest analog
To
the disclosure discussion that we're having now. And then the other interpretations that you've offered in the criminal context or in using that terminology in the context of a burden for a preliminary injunction. But it sounds like the context that by far is most analogous to today's discussion is Buckley v. Vallejo, which comes from the Supreme Court. And that decision provides the context of reasonable possibility. Probability, sorry.
May I ask you something, Monica?
Please. Go ahead.
Thank you. Nicholas's argument is there is a constitutional mandate that we use a standard called reasonable probability. But as I understand the constitutional mandate, we have no case or no instance that is the same as ours here. We are drawing analogies from various contexts. So to argue that there is a constitutional mandate that the New York State Legislature and we follow some standard, even a comparable one, doesn't exist on the federal level. So it seems to me that if New York State sets substantial likelihood, whatever substantial likelihood means, it may mean something stricter than or less strict than reasonable probability. The argument that's being made that the Constitution mandates, there's some constitutional law in case law, statutory law, that mandates that the legislature was imprecise, it was wrong. It should have used reasonable probability. So I got to reject that because we have no standard in this context, either in this state or on a federal level or any other state that I'm aware of. But so I don't really understand the argument, but my recollection is, Monica, that several years ago we did use a different standard. That substantial likelihood was not the standard we used. Am I correct about that? And then.
Yes, you're correct.
And I drew to your attention at that time that we should follow the statute. And we did. Until now, until Nicholas raised it as making it sound like some constitutional imperative, we didn't argue about it much. But we began with a different standard. And then we moved over to substantial likelihood so that we mirrored what the legislature said we ought to do. This is like a lower court and a higher court. The Court of Appeals rules, and lower courts should follow the ruling of a higher court. The court we look to, or the law we look to, is the law in the statute. We're not at liberty here as an administrative agency to write law. And the notion that's being proposed is that we rewrite the statute, and that's not our function. So I would disagree with that, especially since there's no constitutional imperative anybody has pointed to.
I think, Commissioner, that the executive director made a suggestion, which is what I would recommend, which is that to resolve these issues, if in the discussion the commission considers applying the lowest possible standard, does the evidence even satisfy it? If the commission concludes, or Commissioner, that the evidence present doesn't even satisfy the lower standard, then this debate becomes moot.
And I think that can be, I think that can be done consistent with the express statutory mandate. The commission would look at it under the terms of substantial likelihood, as we know, or as it's being discussed here. And if it's also the opinion, even had there been this other standard, if this is where the commission goes, the evidence would not have supported it, if that's the way the commission finds it. And that may obviate the need of going into...
Well, can we take a look at what's actually before us? I think that's what you're asking us.
I think that's exactly what I'm suggesting.
Okay, if you don't mind, Andrew, thank you for the discourse on what the NYCLU has given us. I think I agree with the NYCLU with one thing. They get a lot of mail.
Yes.
Okay? But looking at what they got, as a commissioner, some of the mail supported the President Donald Trump's election. Some of it supports right-wing causes. Some of it actually supports environmental causes. There were some Christmas cards, some that were, the language is not the type of language that anybody in this room or in New York City or elsewhere might use connected to this commission, but nevertheless, it may fall into the category of protected speech. So I think when we parse through everything before us, I don't think they meet any real standard. And history is going to support us, at least up till now, because all they do is get mail and nothing else.
And the question I had asked was what the history has been with the folks who have been disclosed and whether they are, in fact, part of that application.
They also get bombed.
I don't think it's fair to be so dismissive to the NYCLU and to the people who are working there and to the people who have been subjected to personal threats. I think that does a disservice to those people, and it doesn't represent the application accurately. They don't just get mail. They get threats. They get threats of their personal life and their property.
It's no different than what happens in the sports industry, just from past experience.
Say that again?
It was no different than what happens in the sports industry from past experience.
The sports industry?
You say, I'm sorry, we missed a few words there.
Yes, in my former life in the sports world, these letters are no different, and the threats are no different.
Meaning what? That you conclude that they are just letters and don't rise to the standard that we're applying, whatever that standard may be at this moment?
Yes.
Okay.
Can I make a proposal?
proposal.
Go.
So I think there's two things on the table. I think there's the application from the New York CLU and whether they meet, I guess we're using the lowest standard. But I also think there is the commission definition of substantial likelihood, which it is very apparent from this discussion is unclear. It's unclear to us, it's unclear to applicants, and we cannot hold people to a standard. I mean, half of this application is arguing about what substantial likelihood means. The majority of this conversation is arguing what substantial likelihood means. It's our job as a commission to provide a definition outside of a specific application. I would posit that that is, the onus is on us, and we have an obligation to provide a definition that we all can agree on or at least vote on and offer it out to the public. Why is that important? One, it'll, I think, guide people's applications in terms of the standard that we will be using in an affirmative way rather than doing it as a piece of guesswork of, you know, do they meet, you know, reasonable possibility? Do they need to meet a preliminary injunction standard? What do they need to meet a substantial likelihood standard? But it would also allow them the opportunity to challenge us in court if we're offering something as a standard, or for the legislature to correct it if we're interpreting it in a way that's inconsistent with legislative intent or the statutory language. So I think the way we're operating now puts applicants and the intended recipients of this exemption in the worst possible position because they can't challenge it in terms of the standard, nor do they know what we're going to apply. So what I would suggest is we vote, or I don't know where we are, or if we're deferring or whatever it is, but we deal with this specific application, but make it a priority agenda item for the commission to put forward a definition that we will use and that we will offer to the public in considering these applications and will use going forward. And I think that will offer clarity and offer the ability for somebody to challenge us or the legislature to correct us if we are doing so that's inconsistent with the language of the statute.
Commissioner Small, if I can just point, and to your point, which is well taken, one of the items we have set for hearing on October 30th are the source of funding regulations. So that opportunity will be is before the commission. We have the regulations that are there now to govern conduct, and regulations can always be amended. Obviously, they take time, but we've commenced. We have a process that is ongoing, and we'll have comments due October 16th and a hearing on this topic, amongst other things, in our proposed regs on October 30th. So that what you're talking about, I think we've already teed that up. So I think that's already available.
Is there a definition for substantial likelihood in the proposed regs?
No.
Okay. What I am positing is that this is an ongoing issue and a problem, and it is on us to clarify and fix it. And if we're proposing regs and we can do it through those regs, I think we need to offer a definition that we are proposing for the commission. We should allow people to comment on that in the public forum if we're having a hearing on those regs, and we need to get them out so that, like I said, if it's going to be the position, whatever the position the commission takes, people should have the opportunity to challenge our definition and our interpretation, whether it's inconsistent with the Constitution or inconsistent with legislative intent. But it's not fair, nor is it efficient to kind of continually have this discussion about what the definition is. The definition is what we say it is, and we should use that going forward. And so what I would propose is that we come up with the definition and offer that for commission discussion. We should put that out to the public, offer that for public comment. We should finalize that definition as part of the proposed regs. But that should not be a sidetrack process, having now sat through being a relatively new commissioner in comparison with some of my colleagues, but having sat through 3 or 4 of these exemption applications, this is always the issue about the definition of substantial likelihood and whether they make whether they meet that standard. So I would make this a priority. Put forward a definition that the commission can at least put out for public comment or vote upon, and then include that in the upcoming regulation that we have out for public comment.
Let me ask a question in light of that. If we go that road, but yet vote today on NYCLU's application, and we come up with a definition that is somehow different or appears to be potentially different than the basis for our either denial or approval of NYCLU's application, isn't that a little backwards, shall we say? And if we put it out for comment, I'm just not familiar with how long a process that is. At this juncture, we have an application pending that we have to deal with. And so I don't even know, Seth or Monica, can we even punt this application to the next meeting and try to address Commissioner Small's issue in the interim? Is that even possible?
I don't think we certainly can't amend regulations in the next 30 days. If the commission decides, and we do have SAPA regulations out there, we'll get comments. It goes through that process, and that will not happen before October 31st.
Okay, so then let me propose a gloss, Commissioner Smalls, to what you suggested. I agree that to the extent this is a repeating issue, that is to say, what is our definition of substantial likelihood, then it should be addressed and it should be clarified. Since we're not able to do that in as timely a fashion as we might otherwise like, and since we have a pending application, then it would seem to me, let's deal with the pending application today. Let's debate among us in an efficient way, if we can, now, whether we think NYCLU's application meets any of the standards. So we don't have to agree today that it should be substantial likelihood means reasonable probability or any higher standard than that. I think all we need to determine is whether there are enough of us who think it doesn't even meet the lowest possible standard. Then we can deny the application, if that's our conclusion, with an appropriate record, and then we can clarify later on throughout, through the regular process. Marvin, go ahead.
Yeah, just for the record, these filings that have been made by NYCLUS, is there anything in the record that shows that these donors on these filings of 15 and 16 were threatened?
There doesn't appear to be. Some of the donations are affiliated donations from the American Civil Liberties Union, and the record does have items in there of that they lay out having to do with affiliated offices.
Well, these are not affiliated. New York Community Trust is not affiliated.
That's a single.
So my question is simply, you have donors here.
Okay.
Were any of these donors threatened in the last year or two?
There doesn't appear to be anything in the record related to those.
And Commissioner, just to be clear, the question is, were any of those donors subject to threats, harm, or harassment?
Yes.
And I think Andrew's answer is from the record that NYCLU has produced. The answer is no.
Exactly. Thank you.
Right, not to in any way diminish the seriousness of the writings and threats that they've gotten. It doesn't appear that NYCLU has been able to link up. I mean, if it exists, they haven't given it to us, which is the link up to any of their donors, rather than just general threats and harassment, which are terrible in and of themselves, but don't meet our standard.
Whatever the
I wanted to be careful that there are the factors and the evidence that the commission laid out in the regs don't actually require that there is evidence of harm to donors, but it is certainly something the commission should consider in making its assessment, since some donors have now been disclosed.
Just to get comment.
Anybody else want to be heard?
Oh,
Yes.
so what's interesting in looking at this, it seems that the standard, at least under the regulations, isn't necessarily the potential of actual harm, but of harassment, right? Is that accurate?
What, yeah.
So my point is, and I guess harassment can constitute harm, but one of the things that's interesting in this scenario, I guess, in order for a donor to be harassed, someone would have to go through the process of looking it up on the JCOPE website, figuring out who the donor is.
I didn't find it.
And I guess one of the interesting things about that is, some people might argue that that's a remote chance of occurring. And the difficulty is sort of hinging it on that. Is somebody going to look up and figure out who the donor is? And my sense is that's one of the reasons why in the regs, part of the consideration is whether there has been harassment with regard to the entity that's the filer. And one of my questions in looking at this, just trying to get perspective, is have there been any of these, what are the circumstances under which these exemptions have been granted in the past? So I'm just looking at the types of communications that support this application, and I'm wondering, what's been approved in the past? Has it gone above and beyond the examples that are in this application?
Well, Commissioner, since the initial application from NARAL, which was granted, and then due to changes in the regs, several applications were granted until the regulations were amended and the process was changed. Since those initial applications, the Commission has not granted any exemptions.
Okay. Because one of the things I'm thinking of is, and Monica, one of the harm type standards occurs in FOIL, in terms of whether or not a disclosure could likely cause harm to someone. And it's just interesting, and I haven't been involved in the history of this, but I'm just wondering, at what point does it get to the factual scenario where it's, okay, there could be harm to a donor. And when I look at some of the submissions made with regard to this, there are certainly issues in terms of, is it protected speech, is it this, is it that, but also sort of the flavor of a lot of this. And I look at it and I think to myself, how far does someone have to go on the outside with regard to their harassment to say, yeah, you don't have to disclose a donor's name? So that's sort of the thought process that's going through my mind on this. And I'm thinking, when I look at it, I don't think I'd necessarily want to hinge my vote on, is the real rub here whether someone's going to go to the JCOPE website and look it up and connect the dots. That seems a little too, I don't know. If that was the standard, then what exemptions would be granted? So I'm just trying to figure out historically, just to kind of, I guess, help me in my process. I understand the comments made with regard to the type of communications submitted to NICLU, but I'm just wondering, historically, was there a thought process in terms of how far does it have to go in order to say, yeah, that's a problem?
Commissioner, I don't think the commission has actually discussed that particular issue. I think the point about whether any of the donors who have been disclosed have been subject to threats of harm, harassment to their property or people, to them or their property or people affiliated with them is just one of the factors that the commission can consider. As you mentioned, it's taking into account the fact that someone would go onto the website and figure out who's been disclosed, but that is what the ultimate issue is that is someone going to go onto the website and look at who has been disclosed and then subject them to threats, harm. I mean, that's what is there a substantial likelihood that is, going to happen? So again, it's just one of the factors which the commission can consider, but the commission has not really discussed what you're asking. So
let me see whether I can bring this to a head here. We need to have a vote. It seems to me that an application was made to us last time. That application differs not in any real material way that I can see from this current application. We denied the last. The letter is part of their application this time. But I think we need a vote on whether or not to grant the application. So can I have a motion, please? Move to grant the application.
I second it.
Second, okay. All in favor of granting the application?
Mr. Chairman, on the motion.
Yes. I'm sorry, you need to speak into the mic, Gary.
I'm sorry. Here we go.
You got one there?
May I reiterate a position I previously stated to my colleagues? Substantial likelihood of harm means more likely than not to occur. The applicant has not met this standard. Nonetheless, even adopting the standard propounded by the applicant, of reasonable probability they have not met their own standard, I vote no.
You get to do that next.
Well, it's on the, I was on the motion.
Thank you. Hold on. We have a motion to grant
Explaining your vote.
and a second. All in favor of a motion to grant the application?
We have Commissioners Deering and Sample in the affirmative.
and we have Commissioners Cohen and Smalls.
Okay, all opposed?
Opposed, Commissioners Levine, Weissman, Knox, Jacob, and McAuliffe.
Okay, the motion does not carry.
As in the past, we'll prepare a letter that will explain the reasons and circulate it accordingly.
All right.
So
Oh, yes.
before we leave this issue, are we going to provide a definition for the public rather than
We should.
Gary making the statement before we do every vote?
Yes.
About his interpretation of substantial likelihood versus mine or anybody else?
Yes, we should. Seth, can you
We'll draft something.
tee this up for us?
We'll tee it up for you, but it'll be, since it's something that will dovetail into our current process since we've started it. That will require a further amendment of what we have out there, but we'll start drafting something for circulation to you commissioners before the next meeting.
I think it's
Great. Let's put it on our agenda for the next meeting so that we can have a fulsome debate about this again and come to a conclusion that we then codify through whatever the rules
put out that we would presumably put out for public comment.
Yeah.
Well,
I just think we need
regular process.
I think that's
not
going
a moving target.
That's inevitably going to happen, Commissioner. So don't worry about that, because if it dovetails into our current process now, when this comes in again in November, that would be a substantial amendment, I think. So we're on your road, Commissioner, on that.
Okay, thank you.
Thank you. Item 6, new and other business. Seth?
This is not for vote. Of course, that is not, I gathered, typically what's done, but we have a proposed meeting schedule for this first 6 months of next year for your review. I tried to coordinate it with various religious holidays. Just take it home, think about it. I think Catherine will help coordinate any comments you may have, the way Deb has done in the past, in terms of coming up with any alternative dates, but we've tried to stick to the last Tuesday in the month when we can. I think the exception is May. I think Shavuot comes the last week, and we're trying to avoid that, so we'll do that a week earlier.
Okay, thank you. That concludes the public session, so can I have a motion, please, to enter into executive session? Thank you. Thank you. Seconds. We have all manner of people. Thank you. All in favor?
All the commissioners.
Thank you. Any opposed? Okay. We are adjourned.
Please stand by.
Executive session.
Please stand by.
And we're moving into
Sorry,
executive
sorry,
session.
Seth, someone will let us know when we're in executive?
Yeah, please stand by. I'm going to come back.
When is the next? When is
No. We're just waiting for Lori to give us the signal.
I do like 4,000 miles a year.
Ooh, you're more than me. I'm over too.
Yeah, I do like.
We're in public session.
We are in public session, Mr. Chairman.
I did that 1 year.
Okay, thank you. Monica, item 8, please, public announcement of actions from the executive session.
The commission discussed personnel and litigation matters. The commission approved an application under 73(8)(b). The commission discussed various pending investigative matters, and among other things, it approved a settlement agreement, and it commenced 2 substantial basin investigations, and it approved steps relating to several different investigative matters.
Thank you. Can I have a motion, please, to adjourn the public meeting? Thank you, Commissioner Small. Second? Thank you, Commissioner Cohen. All in favor?
Unanimous, Albany.
Unanimous in New York? Okay. Thank you, everybody. We're adjourned.
I'm just not sure what it is. I'm sure I've learned it. I'm just not sure what it is.
Here, right?